Commission for Women. They took some initiative, my lord, to inquire into the whole matter. Kindly see page 33. At the top, reminder that possibly the other letter is missing with us. Then, my lord, kindly see, inviting a reference to the above, you are hereby requested to furnish the latest development regarding disbursement of the pensionary benefit in respect of late Shochipati Ghatak. Within 15 days, my lord, there was no iota of doubt of my entitlement to get, my lord, the pensionary benefit at that point of time in the year 2015, my lord, by, my lord, Special Officer Pension, Directorate of Health Service, West Bengal.
Yes.
Then, my lord, kindly turn to next page, 34. Here, my lord, as to why my claim for compassionate appointment has been rejected, my lord, they have taken this plea. The application was filed after a considerable period of time. No, my lord, that is within time.
Three-man committee report was not.
We don't know, my lord. That was not forwarded to us. These are the.
Was within time, you said?
My application for compassionate appointment, page 23.
81 was your.
Yes, date of death. And, my lord, within the 2 years stipulated period, I have applied.
But you approached the tribunal after.
Yes, my lord, that was some mistake, my lord. Helpless person, my lord. They are, that being the situation.
So your application for compassionate is which page?
My lord, kindly, lordship will find from page 23.
Page
23 and then, my lord, 24. 24, my lord. Prayer for Srimati Bhakti Rani Ghatak for employment of her son on compassionate ground.
This was on 84.
Yes, my lord.
How you are saying that it was within.
No, my lord, that is my mistake. But the Shochipati died in the year 1981, the December. My lord, there are certain gap, my lord.
Yes, then yes. What? Then what?
Here, my lord, the rejection ground was there.
But very good. What other document do you want?
I'm sure. On the first round of litigation, my lord, the State Administrative Tribunal is rejected. Then, my lord, this honorable court relegated this matter with a certain observation.
Do you have the original application copy?
My lord.
Clear portion of the original application. Do you have it?
That is not enclosed over here, my lord.
Yes, next.
Page 50 may kindly be looked into as to why this was, my lord, the findings of the, my lord, on Reed Court.
That is after demand.
Yes, no, before that.
Page 50 is after demand.
No, my lord. Oh, yes, before that, my lord, before that. I'm coming. Kindly come. My lord, here, my lord, page 42, second paragraph.
Yes.
Fourth line, there being no prayer for setting aside of the order denying compassionate appointment and for a consequential direction upon the respondent to consider the case of either of the petitioner for such appointment, the tribunal was in error in not examining the prayer made in the original application for release of death cum retirement. The thing is this, my learned friend submitted that of record, as a result of which in the first round of litigation, tribunal rejected my claim. Well, that was not.
No. He didn't say that. He said that it was dismissed since you have approached belatedly.
Deeply obliged, my lord. I am correcting myself. Then, my lord, lordship, kindly come to page 46. That is the, my lord, the second round of litigation before State Administrative Tribunal.
Yes.
I am drawing lordship attention, page 50. But after skipping 3-4 line, second paragraph, the application, the death certificate is with the respondent authority, appropriate order may be passed, referring to the reply filed by the state respondent, particularly paragraph 15 thereof. It is submitted that since the service book of the disease is not available, no new service book has been directed to be constructed due to lack of instruction. My lord, the only stumbling block, lack of instruction from higher authority. And as it is evident that if directed, service book can be reconstructed, appropriate order may be passed so that the relief sought for may be granted.
This is your submission.
No, kindly see, I am showing, my lord, page 236. They are affidavit before the tribunal. Paragraph 15. Well, referring paragraph 15, we have made this submission. Subject to correction, lordship will decide, my lord, whether that was our proper submission or not. Page 236, I am drawing lordship attention, paragraph 15, page 240. That's you got it, may I read?
Yes.
With reference to the submission made in the paragraph so, I submit that no further arrangement for compassionate appointment could be made due to the lack of proper instruction. My lord, since 3 months committee and thereafter nothing done, possibly my lord trying to explain by the state advocate in the state administrative tribunal. I submit that the service book of the disease is not available and no new service book has been reconstructed due to the unavailability of instruction from higher authority, and adequate information for reconstruction of service book is available. So my lord, this is their affidavit. On the basis of that, we have made the submission, and court was kind enough, honorable tribunal was kind enough to direct the appropriate authority, my lord. That is, I am reading, my lord. Once again, my lord, same thing. It appears, page 51, I am reading. It appears from the annexure that the Shochipati Ghatok worked in Katwa SD Hospital, Badwan, so and was paid salary up to 18th May 1965. So, my lord, so far the liability of payment is concerned by the Katwa up to 18th May 1965. Whether the payment has been made by the LM hospital, it is up to the LM hospital to supply all those documents. When he was on deputation on LM hospital, my lord, once again, my lord, subject to correction, deputation.
Is it believable, Mr. Chakraborty, that my husband last got salary in 1965?
That is there, my lord.
Their version.
Their version.
So from 65 to 1981 is a period of 16 years.
Yes, ma'am.
You will not produce a single document that only this is the payslip. Any one document.
Only difficulty, my lord. Only difficulty. Once again, I repeat and reiterate, the document which they have sent after the death of my father or death of my lord, the husband of Bhaktipati, my lord, we are trying to, my lord, enclose all those documents. Possibly these documents are not I with it.
We are asking you, your wife expired in 2006.
My lord, this is a illiterate lady of village.
No explanation for that.
My lord, illiterate lady of a village, illiterate, and son and daughter at tender age. That was the explanation given by the
admitted fact, Lord, that you also do not have any document to establish that there was any service rendered by your father.
Because of for that reason, and the question of burden of proving presumption are arising.
Right. Yes.
Lordship will decide.
You want to show us?
My lord, page 51.
We have seen page 51.
Therefore, thereafter, no records are available. He expired on so-and-so. There is a death record, dearth of record, as it appears from the reply that service book could not be constructed due to non-availability of the instruction. And my lord, this application is disposed of, directing the Chief Medical Officer Bardhaman, the respondent number 3, to first decide of coming of finding order regarding the identity of the application. Possibly, my lord, there is no, my lord, iota of doubt so far my identity is concerned. They went to my house on innumerable occasion. Police went there. And my lord, they have taken signature from me, and length of service of the disease government. My lord, turn to next page kindly, my lord. Employee of Shochipati Ghatok, after verifying the record within 8 weeks from the date of presentation of a copy of this order, if he is satisfied about the identity of the application and confirm the length of service of the disease government employee, he shall immediately seek the necessary order of reconstruction of the service book. My lord, nothing done, no appeal preferred by them. They are not asking for, my lord, the modification of this particular order passed by the honorable court. This is not supervening impossibility. Impossibility cannot be implemented in any manner whatsoever. Then, my lord, when the state administrative tribunal was not available, we approached the Lokayukt, and Lokayukt passed certain order, and thereafter we approached this honorable court, my lord. Now, my lord, lordship, kindly see. My lord, there must be in each and every government house, my lord, there is, my lord, rules to maintain record, to destroy record. Here I don't know, my lord, this is not beyond my knowledge, my lord, I kindly excuse me. For destruction of this record by the Katwa hospital is still maintaining the record. They are of the opinion 65 is okay. After 65, we are in dark. So far LM hospital is concerned, they are not in a position. So far the Directorate of Health Service is concerned. So it is to be presumed, once again, my lord, record is required to be maintained. Service book is required to be maintained, my lord, in a, my lord, the indefinite period. Here, my lord, how the record was destroyed, my lord, they did not explain it. And on the number of occasions,
they did not say destruction, they say not available.
No, not available. They are not denying that I am not their employee. They themselves term me as
yes, certainly. They are saying that you 1965 you received the salary, deputation, no record.
No.
No record. So this writing died in harness is a discrepant observation made.
So they themselves, COMH of Bardhaman, DHS of the state of West Bengal, every authority at that point of time took all initiative. They formed 3-man committee, and requested me, or they intend to know whether I intend to join in the service of police also. That being the situation.
Where do we find?
Lordship, kindly come to my lord. This
page
25. The page 26 is the typed copy. 9. Whether the candidate is willing to be employed in the post of police constable, because compassionate appointment, father was the driver, son was not. Possibly, if so, the measurement of chest, height, weight may please be furnished. Written consent to this effect may please be furnished. Agreed measurement are given below. These are the agreed measurements.
You were a minor at that time.
True, my lord. Sometime, my lord, when the application has been made, they are not raising that question. They can insist the Bhaktipati to do the work of Group D. That was not their intention. They are in favor of their family at that point of time.
Anything else, Mr.
My lord, this is my lord humble submission, my lord. Now, my lord, I intend to rely upon 2-3 judgments subject to lordship. My lord, this is I have. My lord, 2004-9 SCC. 2004-9 SCC. Para 6.
Para
6. Page 68. Sorry. 2004-9 SCC, page 68.
Para 4.
Para 6, my lord. Para 6. The only point for consideration is whether the respondent was in service or not at the relevant point of time. The tribunal, only on the basis that she was not able to produce the appointment letter, ruled that she was never in service. On the other hand, the High Court, relying on the document like transfer order and joining report, found that she was validly in service. There is also a positive evidence to that effect that she was paid arrear during the relevant period of time. On this goes to show the president of the district board appointed her as a teacher and she was working as one. This is one, my lord. Then, my lord, turn to the next page, last 3-4 lines, page 71. But after skipping 1, 2, 3, 4, 5, 7, 8 line, once no order of termination or dismissal is produced. So far, they did not produce any document. Even, my lord, they did not indicate there was a disciplinary proceedings for unauthorized leave. So, my lord, nothing produced on the part of the state authority, my lord, that being the situation. Now, my lord, I am relying upon Tarsem Singh judgment, continuing cause of action, my lord. My lord, no third party right has been created. It is a question of my terminal benefit. My lord, I can, my lord. Paragraph 5 and 7, I am not reading, my lord. This is widely.
He has not said that your claim is delayed.
My lord, kindly,
your compassionate claim was delayed.
And the other question is.
No, Mr. Siddiqui said.
So, my lord, I am not relying upon this Tarsem Singh.
That was
Lordship. Then, my lord, kindly come to my lord. Already, even in the year.
Paragraph 23.
But I think, my lord, subject to correction, presumption
is para 23.
My lord.
Yes.
The question of presumption, my lord, it is to be presumed, my lord, I was in service and continued up to 1981 is squarely applicable so far my case is concerned.
Which one you are?
My lord, para 23, it is settled law. The presumption of fact is a rule in law of evidence that a fact otherwise doubtful may be inferred from certain other.
Where you are reading?
Para 23, lordship.
Yes. This quote in Vidya Devi. 23.
No, my lord, 2012 10 SCC, lordship, got it. My lord, the pagination which I have made, so far my copy is concerned, my lord, my clerk did not do it.
T. Shankar Prasad.
Tulshiram Sadhu.
No.
Surjo Bongshi. My lord, after Tarsem Singh, my lord,
Tulsiram Sadhu. Yes.
Lordship. Para 23. It is settled law that presumption of fact is a rule.
প্রথম 1 2 3 4 5 6 7
কি করেছিল বাবা?
Yes.
My lord, most humbly and respectfully, my lord, I am reading, my lord. It is settled law that presumption of fact is a rule of law, rule in law of evidence that a fact otherwise doubtful may be inferred from certain other proof fact. When inferring the existence of a fact from other set of proof fact, the court exercises a process of reasoning and reaches a logical conclusion as the most probable position. The above position is strengthened in view of section 114 of the Indian Evidence Act 1872. It empowers the court to presume the existence of any fact which it thinks likely to have happened. In the process of the court shall have regard to the common course of natural events. Turn to next page, human conduct, etc. in addition to the facts of the case. In these circumstances, the principle embodied in section 106 of the Evidence Act can also be utilized. So, my lord, my humble submission, even in the year 2015, they wrote us a letter and referring, my lord, to file of
2015.
Yes.
Which letter?
My lord, letter of lordship will kind enough, my lord, to see page 34. Page 34. They have referred to, my lord, file. One relates back 2009, the other 2011. In response to the above mentioned memo, the undersigned would like to inform you that instant case has been in a file bearing number so-and-so of this office, from which it reveals that the prayer of the applicant has been rejected by the memo number so-and-so on the ground of latest submission of prayer as the
File was relating to compassionate appointment.
True, my lord. Since the question of my employment cannot be doubted, because a terminated employee cannot ask for, my lord, his relative cannot ask for, my lord, compassionate appointment. Cannot ask for, it's not a question of temporary employee. Then, lordship, kindly come to, my lord. There is some, my lord. Then after skipping, my lord, 6-7 page, my lord, lordship, kindly come to, my lord. 1994 Supply 2 SCC 56 Bijoy Narayan Singh versus Superintendent of Police.
94 Supply
SCC 2 SCC page 56. My lord, lordship, kindly see the bold portion. Duty of government to justify its action either by proper pleading or producing record.
Where you are reading?
My lord, the bold portion. Lordship, got it?
Yes.
Termination declared invalid on account of failure to do so by the state government. So, my lord, there too, my lord, no pleading has been, my lord, in the four corner of the, my lord, State Administrative Tribunal, in the division bench, on the earlier round, and in the REET court also. My lord, they have filed their report. Only one plea, record is not available. Paragraph 4.5, my lord, I am indicating. Now, Lordship, kindly see next judgment 2004 3 SCC 753.
Yes. Anything else?
This is, my lord, only one. Paragraph 9, 10, and 24. And then only one.
What proposition?
My lord, the proposition, that is the presumption. Presumption. Over and above, my lord, Lordship, kindly indicated 114D, very specifically, withholding based document. They are the custodian of all document, my lord. They are the custodian of all document. G. But I may be excused. G, my lord, is the Lordship was kindly. And last judgment I have referred, my lord, that is Shuk Datta Ratra, my lord, the delay. State cannot evade its legal responsibility toward those taking the, my lord, guard of delay and all this. My lord, possibly that question has not been raised by my learned friend. So, my lord, considering all this aspect and the judgment my learned friend has referred relating to, my lord, employee who is a leave. Here, my lord, judgment my learned friend referred, my lord, is the industrial dispute related problem, and my lord, 240 days and other question where, my lord, the employee, he is also a person who knows everything, is a leave. He is contesting, he is making a claim that I am entitled, and the court was kind enough to observe, no, you cannot. It is your duty. Here, my lord, this gentleman died at the age of 50, and at that point of time, his son and daughter, my lord, was tender age, and my lord, wife also, my lord, illiterate lady, died in the year 2006. My lord, considering all this aspect, my lord, the OA application is available. Page 130.
130.
এটা তো প্রথম ওয়ে।
হ্যাঁ, সেটাই কন্টিনিউশনে চললো, তো ওটাই তো রেলিগেট করবে।
পরিষ্কার বলে তো there are certain statements which accordingly orderটা সেটা সাইড করলাম, সেটা সাইড অর্ডারটা তো only একটা ছিল, এই অর্ডারটা সেটা সাইড করলাম
accordingly
Sorry, Mr. Siddiq.
Tipler.
এটার সাথে এটা পার্টি, এটার সাথে এটা।
This is my appeal regarding without excise license, Bengal, under Bengal Excise Act.
You are, who is opposing you, Mr. Mitra?
The government of West Bengal. Sorry,
The learned advocate general is appearing in this matter.
Yeah.
Lordship.
What you are saying?
Lordship, the learned advocate general, if your lordship kindly takes up this
Yes,
matter.
matter is hard because the court number 1, as an advocate general, had made his submission. I made my submission, he gave a reply, means the advocate general. Then time came for my reply. Then the court
Determined.
1 year suspension.
We can, as it has been substantively heard by that court, we can release the matter.
The bench, not this bench,
Huh?
not the present bench, ma'am.
That was
Yes, we are sending it to that bench.
So that bench is not sitting anymore.
It can be assigned and taken up. What is the problem?
It's
No.
Justice Hiranmay Bhattacharya.
You will make a joint prayer, it will go to the Chief Justice.
But that bench will not say, please don't say that. But that bench will not, has to be heard afresh by a new bench.
No, if substantive arguments were
That
advanced,
was made 1 year before.
That bench is not sitting
That is
anymore.
what that bench said. It will no longer, that will be afraid. Then determination change.
It has to be heard afresh
What the-
anyway.
Matter is pending for more than 1 year. But that will now come to a minor determination. At least we get a chance of hearing to the conclusion. A license was granted, temporary license. All excise licenses are granted temporarily. For 6 months normally. Within 19 days in our case, the license was suspended. Not because of any breach on my part, no. On the ground, Excise Commissioner said that general election is coming. Therefore, Election Commissioner has requested me to suspend licenses granted under Rule 4Q, not other licenses, only Rule 4Q. Suspension remain. Absolutely can be seen if it is general election of principle is that there is no sale of foreign liquor, then all license will be suspended, not a Rule 4Q. The request of the Election Commission has not seen the light of the day. There's one point, what that? Anyway, on that basis, that remains suspended. Only 19 days we could use. In some cases 19 days, some cases 8 days. Different. This is 18, 19 maximum. Now thereafter, my lord, election was over. Election over. And there are specific rules that if election
yes.
The election rules provide that election is held in different districts from different times, not all election at a time.
So
So whenever
by the judgment, 18 writ petitions were heard and disposed of. Are
Yes.
there any further appeals?
no, it's
These are the only 3 appeals.
this application are disposed of because by the learned judge,
No,
Saying-
we are saying there 18
Well,
writ petitions were
because
disposed.
where the learned judge said, I am obliged to follow the judgment delivered by another coordinate bench. And that judgment, therefore, I have to dismiss your application. In fact, not even now tell you, this was the really advice of the Chief Justice. What happened, my lord? 18 applications are made. Those are disposed of by the judgment of a single bench, Justice Bashak. Now, we are not one of those 18s.
Oh, you are not one.
No.
Then you are challenging with
But
judgment.
then, my client has advised, challenge the judgment of Justice Bashak, although not a party, and seeking leave to prepare an appeal and condonation of delay.
What happened to that?
Then the Chief Justice said, why are you making so delay and all that? You, you take your application pending, get it hard, placed before the appropriate single bench, and you will follow the judgment of Justice Bashak, and your application dismissed. Then you prepare an appeal from that order. No case of condonation of delay or anything. That's what you see the two orders, Milord. That's what, Milord, we applied. And Justice Single Judge said, I am bound by the judgment of that. I have dismissed it.
Where is that order?
Then we have filed the appeal.
Have you brought that order on record?
Yes, that order I show you, Lord.
Where is that?
Order, that's the other appeal, not on this. Kindly come to page 161.
Which appeal you are referring to? নিজেরাই যাচ্ছি।
Item number 3, my lord, stay application, page 161.
Are you challenging 16th of April 2024 order?
Yes.
Please place that order.
The writ petition is considered in
Now,
presence of the.
Mr. Mitro, this is in respect of one particular writ petition.
This is that matter. We are only.
What are the other two appeals?
Other two follow.
The second,
That's
my
it.
lord, the second one, item number 4, my lord, we are not appearing. The petition is not appearing. We do not know who is appearing, my lord. And it has somehow got tagged because perhaps it relates to the same subject matter, but nobody is
Which
appearing.
is that? Which is that?
Item number 4, my lord.
But
That
I am
tell
appealing.
us the MAT number.
I am appealing in Bodun Malakar matter. Bodun Malakar.
Arun Malakar and Raju Ghosh.
And Raj Ghosh taken any order near.
Raju Ghosh পরেরটা, that's the পরের. This MAT 418, my lord, the appellant is not appearing, my lord.
So where is the order that it has to be hard analogous?
I am appealing the Bodun Malakar matter.
We understand. Where is the order that all the three matters will be hard analogously?
No.
My lord, so far as 418 is, MAT 418 is concerned, my lord, there is no such order. We don't.
Must have been
How
order, otherwise how it is
My lord,
appearing
how it got
with.
tagged, my lord, we also do not know, but with 4, with 5, we have.
So we will dismiss that appeal.
MAT 418, my lord.
Yes.
You are sure whether anybody appeared or you took responsibility? You people do not take instructions.
My lord, my advocate on record is not the advocate on record there, so I do not know.
We don't know whether anybody appeared on there. Since Mr. Mitro was appearing, maybe they were quiet. He is the leading counsel.
My lord,
No, I've got only one brief.
2 briefs, sir. 4, 3 and 5. 3 and 5.
But we have 6 babies, Mr.
We have 3 and 5, my
We can
lord.
intimate that that hearing is starting. We can intimate the
We
advocate
can
record.
ascertain who the advocate on record is,
That
and
the hearing has
maybe that we can.
এসেছিল আগের দিন
হ্যাঁ?
পসিবিলিটি এসেছিল
Sure.
আগের দিন তো
আগের দিন একজন বললো যে আমি দাঁড়াচ্ছি
না, না।
টাইম হয়েছে আমি জানি না।
Tagging.
It is same.
So, Mr. Mitro, we are fixing a date and time. Finish.
Let us start. We have been waiting for a long time. Matters. We can write to the advocates a record of the other matter that the matter is being hard on particular
Yes,
date.
to write to it, we take it up on a particular date. We are keeping it on another date.
And it does
But
start.
Mr. Mitro, learned senior advocate appearing for the
30th June 2 p.m. my lord has fixed that original site matter subject to correction.
Let it appear, na? Let it appear in the list. Mr. Mitra will argue for some time.
And Advocate General will be there, my lord, so continue with the first and second half.
We are happy to learn that he will be there.
Huh?
We are happy to learn that he will be there on 30th.
Well, I am always there, but this one is power fix করেছে
Sir, made appear number one. Appears number one.
Mr. Mitra, that we cannot
Today,
say.
today it will have been one.
Fixed at will. It will under the said heading. It will. देखिए दियो तो
Nothing.
Lordship, will other matters be released since this matter will be taken? Other matters may please.
Whether we will be released, we don't know.
But your Lordship knows very
For the
well.
crowd, we are doubtful whether we will be released. Yes, Kakura.
Well, before learned advocate general comments this again, but I would make a humble request. Well, maybe have the opportunity to examine the records of the trial court, because one affidavit which do not find when I've inquired with the counsel for the petitioner, it is not with them also. A supplementary affidavit was used by the petitioner disclosing, my lord, all their documents. Well, I need to examine that.
There are 44 appeals, Mr.
No, read petition, my lord.
Read petition was
But
Priyanka.
I'm praying for examination of the records of the read petition.
Which read petition?
The main.
There was only one
Read petition. There was only one read petition.
140
Priyanka Naskar.
petitioners, but one read petition.
One read petition.
That is of Priyanka Naskar.
Yes.
Right.
Only inspection of the records of Priyanka Naskar read. Because one of the supplementary affidavit was filed.
Yes, sir.
Well,
All right, you do it in presence of our officers.
we can do it right now. Records are with you.
Yes.
Yeah.
Naskar's matter, were there any private respondents?
No, that is one of my points. That is one of my points, that the persons affected were not parties either in representative capacity or
That you have argued.
yes.
We are saying that apart from 873, in the other appeals, these appeals were all leave to appeal, or was there any similar order passed by his lordship?
No, there's only one appeal. I'm sorry, one order.
So
passed by
there
the
is
learned
only
single-
one order of 12th of May 19.
Right.
But I think you are not right, because I find in the previous order of Justice Sen
Yes.
that his lordship referred to, just a moment. In Justice in MAT 1547,
Yes.
his
That was the
lordship says
1547.
1547, his lordship says learned counsel petition has referred to an order of 25th September 2023 of Supreme Court. We must-
25th September 2023
please
of the Honorable Single Judge.
of the Supreme Court.
সুপ্রিম কোর্টে গেছিলাম
Order was of 12th of May 23. His lordship refers to and MAT 1547 saying that there was an order passed on 25th September in a special leave petition arising out of another judgment dated 19th of June 2020.
19th.
I don't know.
এটা ওকে পুরো
Last paragraph.
Consideration referred to an order passed by the Supreme Court. Arising out of the final 19/6 আমাদের এটা হচ্ছে 12/5 in আচ্ছা এটা MAT
Mr. Dotto,
দাঁড়া হ্যাঁ
there is also another order. I have made a that give it to me. I can find it all. The best of our ability.
966 এটা লেখ কোথাও
Please take note of that order.
yes MAT 960
This order you
Yes,
will
sir.
find. I have shown you this order is an order dated 6th of December 2023.
right
Now there is another order of 26 September 2023.
but of the honorable division bench
Yes, 26 September 2023, where the division bench says that I am allowing this application for addition of party in view of an order dated 7 July 2023. Supreme Court order.
That is my.
Madam, this way we cannot take it because we are not getting any assistance from you. We are with 44 appeals. You have to tell us, at least somebody take the responsibility. Mr. Dotto, if you can ask
I'll take that responsibility collate all orders
all orders and you, because just offhand submission was made that your lordship cannot now allow any further application for addition of party. One submission was made. So when we went through this file, we came to know that observation whether can be taken into account when a coordinate bench in view of a Supreme Court direction has added the parties. So there was again a difference whether you will be allowed to intervene or will you be added as a party.
right right
But in the orders of the coordinate bench subject to correction by you, we didn't find that there was any order saying that yes, I am allowing you to intervene, but the order says I will allow only one counsel to argue. Now we sought for appropriate instruction from department. If there is addition of party, then the cost title has to be amended.
Yes.
That my officers intimate me that has not been done. That is also subject to be verified. We are collating the files of all the 45. These are the small issues because Mr. Dotto, we want to finish it off.
right
So we want to say if any opposition is raised by anybody that those addition of party I will not allow, then we have to consider it, pass an order again, that will create
create another problem.
So if the advocates can at least tell us that all right, you allow those applications, and we will hear in one matter. I think Mr. Pratik Dhar appeared. Yes, that we will hear one counsel, and in reply you give your.
I can yes.
So then the problem gets resolved, and we.
সবচেয়ে তোর এই এতগুলো অর্ডার কার কাছে আছে
আমার কাছে আছে সব আমার
সব
কাছে
আছে শিওর
একদম সব ফোল্ডারে
সব
আছে
আছে
এক্ষুনি দিয়ে দিতে পারবো
তো তোদের মধ্যে কি একটা দায়িত্ব নেই সবগুলো অর্ডার গুলো একটা বাঞ্চ করে দিই? হ্যাঁ? না, তুই যে সুপ্রিম কোর্টে গেছিস, সুপ্রিম কোর্ট থেকে ফিরেছে, সব আছে তোর কাছে আছে?
সব আছে আমার কাছে
সেই জন্য পার্টি অ্যাড করেছে।
এই যে MAT 930
সব আছে।
সেটা ইন্টারিম অর্ডার
আমার কাছে এক মিনিট আপনি চাইলে
কতটার অর্ডার
দেখছি তারা
বললাম তো আমরা বললাম
Now that 7 July order, Mr. Dotto,
Yes,
that is the order passed by the Supreme Court against the Appellate Court order staying the operation of Justice Gangwardhan.
right
But there is reference to another order of 4th July 23. I don't know. That I couldn't find.
Well, what I am suggesting is, Bilal, either Mr. Lahiri takes this responsibility, but I take the first responsibility, or Mr. Bishas.
আমি নিচ্ছি করে
So,
দিচ্ছি।
and I'll sit with them,
No, no,
get
but-
all the orders, each
What we are
sequence.
desirous of is that after your submission, you will hopefully complete it today.
One more thing.
No, no, no. আজকে করে দিও।
Okay.
You will complete it today, and we will hear the council who is supporting your contention.
My lord, if I may, there is a 7th July order of the Supreme Court, Honorable Supreme Court. That is my appeal, my lord.
Madam,
is my SLP.
we are not wanting to know whose appeal is it. We are
My lord is
wanting.
wanting to know who will argue, who will be
Yes,
the counsel who will argue.
Yes.
That is, my lord, I was the one who went to Supreme Court with this is my SLP, my lord. So this is my request before your lordship that we may be heard.
So where we have said that we will not hear you? Have we said that we will not hear you? Repeatedly you are raising the same point. Yes, Mr. Dotto.
Yes.
Please, I have given it to your mind. You please.
Before the returnable date made, we'll prepare a compilation of all the orders, starting from the Honorable Single Judges, all orders, and the Supreme Court as well as the division benches order.
Yes.
Now, on the last occasion, when I was addressing this tribunal, I'm sorry, this Honorable Court, Milord, on the aspect of corruption, Milord, the judgment proceeds চার সুপ্রিম কোর্ট কেসেস লাস্ট দিনে দিয়েছি, ওটা একটু বের করে রাখো। 23/4/731
Yes, as regards corruption.
Right.
You
Your
have referred
judgment
to Black's
proceeds-
Dictionary,
Yes.
State of UP versus Vedpal Singh,
Right.
Chhadia versus State of Madhya Pradesh, State of Andhra Pradesh versus Basudev Rao, Joint Action Committee, Neeraj Dotto,
Yes.
Kim Wangsu,
Yes.
and Deepa Bhai Nanu Bhai Shanghania.
Right.
That's it.
Now, Milord, since Milord, the judgment proceeds on the basis of a potential corruption, where I use this expression potential because the entire presumption was that of a corruption.
We have taken note,
Yes.
Mr. Dotto.
Now,
That-
Milord, yes, since Milord, everything has been invalidated on a finding of corruption. Milord, the Supreme Court in Neeraj Dotto's case, which your Lordship has been pleased to take note of, Milord has
Judgmental copy আলাদা করেছে। Yes.
Milord has discussed in details.
That you have shown us paragraph 22, Neeraj.
Yes, no, Milord, that is Milord only one of the finding. But what was the Supreme Court or the larger bench considering, or what was the reference and what is the ultimate finding on an issue of corruption? That Milord I need to Milord place before your Lordship.
Further judgments, Mr.
No, this same judgment, the same judgment.
Tell us which paragraph you want.
Yes. Kindly take Milord the first paragraph.
Yes. Paragraph?
Milord, paragraph number 1.
Yes.
By an order, a 3-judge bench of this court has referred the question of law framed to be decided by a bench of appropriate authority. That is how this batch of cases has been referred to the Constitution Bench comprising of 5 judges. For easy reference, the order of reference is extracted as under. Your Lordships may skip over point number 1 and 2 or reference number 1 and 2. Please take reference number 3. Noting the divergence in the treatment of the evidentiary requirement for proving the offence under section 7 and 13(1)(d) and 13(2) of the Act, the court referred the following question of a law for determination by a larger bench. The question whether, this is how the question is framed. The question whether in the absence of complainant stroke direct or primary evidence of demand of illegal gratification, is it not permissible to draw inferential deduction of culpability stroke guilt of a public servant under section so and so based on the evidence adduced by the prosecution? Where the reference, my lord, is in the alternative or in the negative, that where there is no direct evidence, can corruption be proved through indirect or inferential evidence? We are in a case where there is no direct evidence. Therefore, how a charge of corruption or corruption as a fact in issue is to be considered is the subject matter of reference, and the Honorable Supreme Court in various paragraphs deals with it and finally comes to the conclusion at paragraph 88. Now, one more paragraph is paragraph 3. With the other part, I am not troubling your Lordships, may not be relevant for me. Thus, paragraph 3, next page. Thus, the moot question that arises for answering the reference is, in the absence of the complainant letting in direct evidence of demand, owing to non-availability of the complainant or owing to his death or other reason, whether the demand for illegal gratification could be established by other evidence. This is because in the absence of proof of demand, a legal presumption under section 20 would not arise. Thus, the proof of demand is a sine qua non for an offence to be established under section so and so, and deholds the proof of demand, the offence under the 2 sections cannot be brought up.
Yes.
Therefore, my lord, in view of the essential ingredient or my lord, the sine qua non, that my lord, there has to be a demand and acceptance or delivery of illegal gratification, whether through inference or through circumstantial evidence, that can be proved.
So your argument is, in the absence of direct evidence, you cannot even infer that there has been
you can infer, but the parameters are laid down later on. The Supreme Court was considering there is no direct evidence.
Now, those parameters, which parameters?
Yes. Now, my lord, if my lords may kindly take, my lord, paragraph 46.
But Mr. Dotto, the word corruption was used in the judgment.
Yes. Yes. But the word corruption has been used without any evidence.
No.
Direct, indirect, nothing.
So far as wrong.
Corruption, my lord, by itself.
It was a passing remark. Can you come back to page 622 of the paper?
Well, I'll come back to that, my lord. Yes.
You may argue that on the basis of a passing remark, you could not have interfered with the 36,000 account.
Yes.
Maybe you, that is.
Yes, finally that.
So, except in page 622 penultimate line,
yes,
there is no other reference. A corruption of this magnitude is never known in the state. This is his lordship's remark. So on the basis of that, how corruption of this magnitude, because the education minister was taken into custody. And now, and on the basis of that, his lordship concludes that the entire selection process.
Yes, now,
was-
yes, before that, my lord, please take paragraph 18, 18, 19.
Mhm. Yes, these
Yes.
are remarks. These are
No. It is please take my para 18 at page 623. It is a matter to be noted that the board in its affidavit in opposition while dealing with all the pleadings of the petitioners, instead of addressing the allegation of corruption and illegalities in the recruitment process, raised some niceties of law and some principles of law. But however nice or however laudable those principles may be, this court as a court of justice will fail to deliver justice, knowing fully well that sense of justice is much above sense of law. If the writ application is thrown out on such niceties of law as this will mean, in the name of preserving the law, the corruption would be protected, which a constitutional court can never do, keeping in mind the soul of our constitution and the constitutional conscience, I must say, in this recruitment scam, stinking rats are being smelled. Therefore, with respect, it's not a passing remark, but it is the basis of the judgment. The basis of the judgment is where there is corruption, don't bring in niceties of law. Then kindly take my paragraph 19, which my lord were pleased to refer.
Yes.
The board placed some judgments before me in support of niceties of legal principles, which I do not find have any applicability in the face of the magnitude of the stinking corruption in the recruitment exercise of 2016 conducted by the board. Those judgments are not required to be mentioned at all in the factual situation of the case, as those are rights as etc. Factual situation of the case. Now, what is the factual situation of the case?
That which has been ascertained upon taking evidence.
Yes. Well, I'll deal
You deal 165 now. You have finished your argument. Now
yes,
you
165, of course, well, I'll have to deal with it. Well, whether at all 165 is applicable or not.
Yes.
If applicable, how it is to be applied.
Yeah, we are expecting that argument.
Yes. But Miller, please take Miller, since Miller,
paragraph 3 you have shown us. Paragraph, yes. Any other paragraph?
Yes. Now, if your lordships may kindly take Miller, please take Miller paragraph number 46 onwards, a few paragraphs.
46 you did not place, Mr.
No, I have not yet placed Miller.
You placed para 22.
Yes. But on the earlier round, Miller, I have not placed these paragraphs.
Yes, what you want to show?
Now, question for consideration. First, Miller, I have shown the reference, Miller, at paragraph 1 and 3. Now, question for consideration is at paragraph 45.
That is repetition of paragraph 3. Paragraph 1 subclause.
Right.
Paragraph. Yes.
On consideration of the aforesaid cases, the question framed for determination by the larger bench is whether, in the absence of evidence of the complainant, direct or primary evidence of demand of illegal gratification, is it not permissible to draw an inferential deduction of culpability, guilt of a public servant under section so and so based on other evidence adduced by the prosecution? Paragraph 45.
Yes, that is the reference point.
Yes. Now, Millard, the Supreme Court is, Millard, because Millard, I was not required to place this judgment. Had the Honorable Single Judge not taken recourse to Section 165 of the Evidence Act, by reason of adoption or taking reference to Section 165, where the whole procedure or the scheme of the Evidence Act is required to be placed before this court as to how an allegation of corruption is to be proved. But corruption is something, Millard, which vitiates everything. No doubt about that. But by merely saying, by merely inferring, by merely
What are the
smelling.
parameters you show
Yes.
us?
First, kindly take my paragraph number 47. Since the main thrust of this case is on the quality of evidence for proof of demand and acceptance of illegal gratification before a public servant can be held guilty under section so and so, it would be appropriate to discuss the salient principles of law of evidence relating to the question under consideration. In this context, it would be necessary to refer to sections 3, 4, 59, 60, 61, 62.
Now, which paragraph it has been summarized?
Yes. Milord, everything is considered from Milord. I kindly note it down. I will not waste the time of the court. Kindly note down the paragraphs. Milord, your lordships may kindly consider.
Paragraph 88 ultimately.
Yes, ultimately. But Milord, before that, I am not placing those. Kindly note down these paragraphs.
Yes.
Paragraph 48.
Yes.
49. 50. 51. 53 is very important. Here, Milord, the Supreme Court is considering circumstantial evidence. 54, 55, 56. 56 again is important because oral evidence is being considered. Here, Milord, the Honorable Court, Milord, had called, Milord, certain witnesses. Then, Milord, your Lordships may skip over 57, 58, 59. 60, 61, 62, then 64. May I place 64, Milord? Then I'll go to Milord 68, 88. Courts are authorized. 59. Courts are authorized to draw a particular inference from a particular fact unless and until the truth of such inference is disproved by other facts. The court can, under section 4 of the Evidence Act, raise a presumption for the purposes of proof of a fact. It is well settled that a presumption is not in itself evidence. This is very important. But the entire judgment proceeds on presumption, but only makes a prima facie case for a party for whose benefit it exists.
All right.
Milord, a court can definitely presume something, but the parties have to come and prove it or disprove it. As per English law, there are 3 categories of presumption. I don't trouble your lordships with those. Then, Milord, skipping over, Milord, 66, 67, these are all judgments, Milord, which has been Milord, considered by the Supreme Court. 68, these are all previous judgments. I don't trouble the court. 69, 70, all previous judgment. Then, Milord, 71, kindly note down, Milord, your lordships may consider it, Milord, at the time of delivery of judgment. Now take, Milord, 73.
Yes.
It is tried law that in cases dependent on circumstantial evidence, the inference of a guilt can be made if all the incriminating facts and circumstances are incompatible with the innocence of the accused or any other reasonable hypothesis than that of his guilt, and provide a cogent and complete chain of events which leave no reasonable doubt in the judicial mind. But the cycle or the chain has to be complete. In a case of inference, and Milord, a case based on circumstantial evidence. Then, Milord, after all these, Milord, now, Milord, your lordships may kindly come to paragraph number 88.
88 you placed, 88.3,
yes.
88.5 you gave.
88.1, 88.3, 88.4 and 88.5. Now, in this backdrop, what, Milord, I have just cited, Milord, the various paragraphs. Now kindly see, Milord, what is the final, Milord, outcome or conclusion of the Honorable Supreme Court. What emerges from the aforesaid discussion is summarized as under. proof of demand and acceptance of illegal gratification by a public servant.
You placed it, Mr. Dotto.
Therefore, first is, may I summarize what the Supreme Court summarizes? Number one is proof of demand and acceptance is a sine qua non. Maybe your lordship will not find a sentence in the judgment under appeal to that effect.
Yes.
Then 88.3 is it can be proved also by circumstantial evidence in the absence of oral and direct evidence and documentary evidence. And
Yes.
then we're 88.4.
Yes.
How to prove demand and acceptance? In order to prove the fact in issue, namely the demand and acceptance of illegal gratification by a public servant, the following aspects are to be borne in mind. If there is an offer to pay by the bribe giver without there being any demand from the public servant and the latter simply accepts the offer and receives the illegal gratification, it is a case of acceptance as per section 7. In such a case, there need not be a prior demand by the public servant because there is an acceptance. 2. On the other hand, if the public servant makes a demand and the bribe giver accepts the demand and tenders the demanded gratification, which in turn is received by the public servant, it is a case of obtainment. In case of obtainment, the prior demand for illegal gratification emanates from the public servant. That is an offense. 3. In both cases of 1 and 2 above, the offer by the bribe giver and the demand by the public servant respectively have to be proved by the prosecution as a fact in issue. But with respect to the entire scheme of the law has been completely bypassed. This is not a magic word, corruption, that can be used and any actions can be negative. Because the consequences are serious. In a case of an allegation of corruption, my lord, the consequences are very, very serious. Therefore, my lord, these strict principles, my lord, are to be applied. And merely presuming corruption, smelling corruption, my lord, these cannot, my lord, form the basis of a judgment.
Yes.
Well, one more subparagraph, 88.5E.
Yes. Yes.
88.5. The presumption of the fact with regard to the demand and acceptance or obtainment of any illegal gratification may be made by a court of law by way of an inference only when the foundational facts have been proved by relevant oral documentary evidence and not in absence thereof. So this is a bar on court to presume corruption, whatever may be its magnitude, but in the absence of, my lord, any proof. And how to be proved? Oral and documentary evidence, and in absence thereof, you cannot infer corruption.
Yes.
My lord, your lordships have read the judgment under appeal. I will not trouble your lordships once again with that. But my lord, the judgment, my lord, proceeds absolutely on the basis of inference, without any proof, without any adherence to the parameters, my lord, which has been in fact collated in this judgment. Where these are all, my lord, section-based discussion, and my lord, earlier judgments have been referred. Maybe, my lord, this Supreme Court judgment has come after, my lord, the judgment under appeal has come, was delivered. But, my lord, here, my lord, all the judgments which have been referred are previous in point of time. Therefore, my lord, these being the parameters,
Yes.
well, my respectful submission is, my lord, no corruption has been proved in the manner, my lord, required by law, and therefore, my lord, the learned judge could not have accepted an allegation of corruption. Now, what is the allegation? I'll come to that later on. And, my lord, therefore, my lord, this judgment should go.
Anything else, Mr. Dotto?
But I have got 7-8 points more, my lord. But please only note down, my lord, the paragraph numbers, my lord, where your lordship will, my lord, have a look at it, my lord, at a time.
Will refer further judgments.
On corruption, I'm over. But only the paragraphs in the writ petition, kindly note down the paragraph numbers on corruption. Then, my lord, I'm done with corruption issue.
That you have already placed.
Very well. Paragraphs 12, 14, 15, 17, 18, 22.
That you have earlier showed us.
Yes, yes. Very well. Very well.
When you were arguing on absence of pleadings, that was done. What else, Mr. Dotto, you want to say?
But the next point is, my lord, that, my lord, your lordships have held in innumerable number of judgments that a writ petition is not meant for a roving inquiry.
That you have argued.
No, my lord, a few points.
That is covered in Justice Shirpurkar's order, which you have placed.
No, my lord,
Hello.
Jordan. Yeah.
That paragraph is there, roving inquiry.
Yes, sir.
You have argued.
Very well. But, my lord, that is, my lord, the principle that I've argued. But, my lord, the applicable facts, my lord, kindly just, my lord, note down the orders on which, my lord, I.
Yes, which?
My lord, first is, my lord, the order dated 6th of December 2022.
That is on the first day you argued. That see the backdrop.
Yes, yes. Just note down the where I'm not placing those. I'm just where I'm, my lord, trying to, my lord, assist your lordship, my lord, on each point. What are the documents or paragraphs that I intend to, my lord, rely?
Yes.
My lord, on the roving inquiry part, my lord, I refer to, my lord, the order of the learned single judge dated 6th of December 2022.
Yes.
Then 20th of December 2022, my lord, I am being asked to disclose documents.
Yes, you have placed these.
Yes, just note down the orders. Then, my lord, 7th of January 2023, 24th of January 2023, and 5th of April 2023.
Very good.
Yes. But these are, my lord, the orders from which, my lord, I, my lord, respectfully submit that this was an exercise of roving inquiry, my lord, under Article 226. My lord, 3 judgments on this. Kindly note down the citations and the paragraph numbers.
You have given it earlier.
My lord, Shodananda, hello, my lord, I had relied, my lord, on what should be the approach of the court in a case of
judgments you are giving.
Yes, on the roving here, three judgments only. But on roving inquiry, I made my submissions, but I don't think I placed any judgment.
We just tell us which judgments you are saying.
My lord, 2008 Volume 4 Supreme Court cases 619.
Yes,
36, 36, 37.
Place
Placed
that
that.
is Sadananda.
Paragraph 58.
And 58, 60,
Very.
62.
Yes, you have placed.
Then, my lord, 2012 3 SCC 236.
12.3 SCC.
2012 3 SCC 236.
এটা করতে যাওয়া। In roving inquiry, you cited the 2010 volume 11 SCC 6-9 and that Ugra Sen judgment.
But that is, my lord, relief granted, not prayed for.
As
Ugra
well
Sen
as-
is relief
as-
granted.
In the absence, no inquiry can be, no such roving inquiry can be made. That was Ugra Sen.
Yes.
When there is no pleading to that effect.
The absence of pleadings, this order could not have been passed. That
Could not have been passed.
Right. Now, my lord, I am saying that fishing and roving inquiry. Just note down the citation, but I will not detain the court. I don't, my lord, please don't have the feeling that I am detaining the court, my lord.
2012.
2012 3
Does
SCC
it-
236.
Do you get that sort of an idea? We are hearing you for the last 3 days. Yes, 2000.
2012 3 SCC 236 para 35. And 2007 8 SCC.
Just a moment.
I'm sorry.
236 paragraph 5 and 2008 SCC.
My lord, 2012 3 SCC 236 para 35. And 2007 8 SCC 418 para 83.
2007.
7 8 SCC 480.
What paragraph?
This is paragraph paragraph 83.
30. এই ঘন্টা না একটু লিখে দাও না 11টা তো অলরেডি 20-25টা দেখিয়ে দিয়েছে yes
Let's see, 165.
যেহেতু এইসব গন্ডগোল Hmm. Yes. Yes, Mr.
But my first submission is, Milord, this is not a case, Milord, where, Milord, section 165 or powers under section 165 could have been exercised.
165 cannot be gone into it.
Cannot be exercised in the case which was being, Milord, dealt with, Milord, by the learned single judge.
Now, evidence একটা তো চলে গেছে। Yes. Yes.
Well, number 2 is, Milord, but section 165, Milord, supplements various provisions of the Civil Procedure Code as well as the Criminal Procedure Code.
Yes.
Number 3 is where only in a case of trial, 165 is exercised by the court, Milord, for eliciting, Milord, some important issues which may have been missed by the prosecutor or the defense. Here, Milord, the court has acted as a prosecutor, Milord, in calling witnesses and examining the witnesses.
Yes.
But here, Milord, the court has, Milord, using the language of the courts, Milord, not my language. Here, Milord, the honorable judge has, Milord, trespassed into, Milord, the shoes of the prosecutor and the defense.
That you have independently argued,
Yes.
that he has acted as a prosecutor.
Yes.
So you
Milord, kindly note down the orders on which I rely. I have placed all those, just note down the orders. Where, Milord, the court has exercised powers under section 165. Where the orders are dated 17/1/2023,
yes,
page 421 of the paper book. Then 24/1/2023,
yes,
page 423 of the paper book. Then, Milord, order dated 6/2/2023 at page 427 of the paper book. Well, kindly, Milord, note, Milord, one feature. Milord, in this order at page 427, the court is selecting the witness.
yes,
Then the order of 21st of February 2023, at page 432. Then order of 5th of April 2023 at page 436. And, Milord, lastly is, there are two orders of 5th of April. The second order of 5th of April 2023 at page 437.
yes.
Now, Milord, 4 or 5 judgments on this way. These are all, Milord. I have in fact reduced the judgments on 165, which I had cited before the honorable single judge, but unfortunately, Milord, the honorable court felt that these are niceties of law and should not be referred even. But the first one is AIR 1968 Supreme Court, page 178. ওখানে কি দেখছিস?
Paras?
68. Paragraph 5, 6. হ্যাঁ? ঠিক আছে। এটা সব আমি স্ক্রিন করে থাকবে না?
Yes.
Online citation of that 67. 67 SC online SC 19. দাদা support কর। Minute 165 is quoted over here. Therefore, I don't trouble your lordship with the book.
Quoted where? Oh,
The judgment itself. Therefore, I don't take your lordship to the book.
yes.
So please take me paragraph number 5.
67 SCC আমরা তো দিয়েছিলাম।
The question falls to be considered under section 540 of the Code of Criminal Procedure. That section is to be found in chapter 46 of the code, among several others which have been appropriately described in the heading to the chapter as miscellaneous. It provides 165. The judge may, in order to discover or to obtain proper proceeding under this code, summon any person as a witness or examine any person in attendance, though not summoned as a witness, or recall or re-examine any person already examined. And the court shall summon and examine or recall and re-examine any such person if his evidence appears to it essential to the just decision of the case. The section gives the power to the court to summon a material witness or to examine a person present in court or to recall a witness already examined. It confers a wide discretion on the court to act as the exigencies of justice require. Another aspect of his power and complementary to it to be found in section 165 of the Evidence Act, which provides
Yes.
the judge may, in order to discover or to obtain proper proof of relevant facts, ask any question he pleases in any form at any time of any witness or of the parties about any fact, relevant or irrelevant, and may order the production of any document or thing, and neither the parties nor their agent shall be entitled to make any objection to any such question or order, nor without the leave of the court to cross-examine any witness upon any answer given in reply to such question. These sections between them confer jurisdiction on the judge to act in aid of justice.
Which
But
is
one
the-
thing that I have missed, Milord, in paragraph 5, the fourth line, 165 is a misprint. It should be section 540. Kindly, if your lordship may kindly make the
540.
correction. In paragraph 5, in the fifth line, 165 is quoted, but actually that is 540 of the.
Yes, the sentence begins with that.
Yes. So it's kindly correct that where it's a misprint in the judgment.
This is 540.
That is 540.
Yes. Now, what is the summarization? Which were? Yes, any other judgment?
Okay, please give me a moment for that. But the next one is 2004, volume 4, Supreme Court cases 158. There are two paragraphs from this judgment, 43 and 44. Paragraph 43 and 44 are only two paragraphs from this judgment.
We shall go through it. You can give us the
Very well.
crux of the principle you can tell.
So the crux of the principle over here is where the object of section 165 is, in my humble understanding, is to elicit some important fact in issue. Nothing else.
So why do you say that it cannot be applied by the judge?
Well, in a case of trial, I am saying, the cross-examiner. I am cross-examining my other side's witness.
No, you have any authority that 165 cannot be allowed in a writ petition?
165 is never contemplated in a writ petition.
That is what you are asking.
That is what I intend to submit before the court. There is no, I have not been able to find out any judge, lay my hands on that. Because trial, it is,
no, suppose something is suspicious to me. Yes. I cannot ask you, Mr. Dotto, that you please come and depose and tell us.
Well, number one is that, a writ proceeding is a order 19 proceeding. Here, your lordships decide on the basis of affidavits. Whatever is annexed to the affidavit or the writ petition, they are considered as evidences.
Evidence.
Normally, your lordships decide on the basis of whatever is placed by way of affidavit evidence. It is not that the court is debarred from taking evidence. In an appropriate case, there are judgments which say that yes, evidence can be laid before the writ court also. In those circumstances where the writ court will, invite the parties to lead evidence. Yes. So the parties have to come, produce their witnesses, lead evidence where the writ court feels that this is such an extraordinary case or an exceptional case where the writ court should step out from the normal procedure and invite the parties to adduce evidence.
But the court cannot call anybody and say that give evidence. Is what you want?
Yes, in my respectful submission, no. Please take the next case that I intend to cite. This is number 81 3 SCC 191.
Yes, paras.
The two paragraphs, paragraph 2 and 3. Akashi 3. আকাশি 3 ঠিক আছে রামচন্দ্র হ্যাঁ Please take my paragraph number 2.
ওকে ইন্সপেক্ট করে গেছে, ওকে ইন্সপেক্ট করে গেছে, দেখতে চাইছে সাপ্লিমেন্টারি এভিডেভিটের কপি ইন্সপেক্ট করবো। এই অগ্রজি আসলে তো yes, paragraphs 3 and 4, 2 and 3.
The adversary system of trial being what it is, there is an unfortunate tendency for the judge presiding over a trial to assume the role of a referee or an umpire and to allow the trial to develop into a contest between the prosecution and the defense with the inevitable distortions flowing from combative and competitive elements entering the trial procedure. If a criminal court is to be an effective instrument in dispensing justice, the presiding judge must cease to be a spectator and a mere recording machine. He must become a participant in the trial by evincing intelligent, active interest by putting questions to witness in order to ascertain the truth.
That is in a criminal trial, you say.
Any trial. Well, here it is a criminal case. Here indeed it is a criminal case. As one of us had occasion to say in the past, every criminal trial is a voyage of, kindly skip over that. Then please take me to para 3. With such wide powers, the court must actively participate in the trial to elicit the truth and to protect the weak and the innocent. It must, of course, not assume the role of a prosecutor in putting questions. This is what the Honorable Judge, in my very respectful submission, has done in this case. The functions of the counsel, particularly those of the public prosecutor, are not to be usurped by the judge by descending into the arena as it were. Any question put by a judge must be so as not to frighten, coerce, confuse, or intimidate the witnesses. The danger inherent in a judge adopting adopting a much too stern an attitude towards witnesses has been explained by Lord Justice so and so. Now, kindly, so far the quoted part is concerned, please turn the page. At page 194, the quoted portion, please take the 4th line from the top. The 4th line from the top, the quoted portion. If he, where he means the judge, if he goes beyond this, he drops the mantle of the judge and assumes the role of an advocate, and the change does not become him well.
So in this case, what the judge has done?
The judge, with respect, played the role of a prosecutor. None of the parties called witnesses. None of the parties were either examining or cross-examining any witness. Rather, the Honorable Court records that none of the parties have put any questions to the witness, which is recorded in the order dated. The orders that I have not placed, 21st February 2023 order, the court records that no question has been put by the parties. Then what is the result? 432.
Parties includes you.
Everybody.
You did not question that.
No, it's not my witness. It's not my adversary's witness also.
You are the respondent. If any evidence is against you, you will not cross. Ask the judge to say that allow me to cross.
The first is whether a trial was being held on.
No, that is separate. That is
unless there is no
trial. Party to that, you did not cross.
Question is, do I commit this mistake by asking any question and transform it into a trial or not?
Oh, that is your wisdom, Mr. Dotto. That is when a trial goes on, certainly
there is no trial.
No, trial in the sense and
then I need to place the orders once again, these 5 orders.
No. By trial, what do you mean?
The trial, my lord, so far as the criminal, I'm sorry.
Don't restrict it to criminal. It is in respect of all proceedings.
My lord, so far as the civil case is concerned, my lord, after the issues are framed, my lord, witnesses examined, thereafter, my lord, the trial begins.
Very good.
In a criminal case, my lord, post cognizance, trial begins.
No.
Neither of these, my lord, procedures, my lord, are adopted in writ court, not in this case. My lord, I can understand, my lord, from the very beginning, my lord, the court was either following the CPC or following the CRPC, considering it as a civil case or a criminal case requiring trial.
Which order did you say, or date of the order?
My lord, the order, my lord,
They did not put questions, none of the parties.
page 432, order dated 21st of February 2023.
Very good.
That is 430.
21st February.
Yes. আরো কিছু আছে নাকি?
Then we are, I'm sorry.
Yes, yes.
Take a civil case. The next one, 1971, 3 SCC 303. This is made in an election dispute matter.
You said you will provide 3 judgments.
71, 3 SCC 303.
Oh.
With this went from the airport. Please have a look at one paragraph.
Wow. Yes, para?
Well, at paragraph 12 of this judgment. Paro.
Yes.
But paragraph 12 made a part of it where I'll place. Another feature.
Mr. Dotto, please, if you can summarize a bit, otherwise we can never finish.
But that's why I'm reading part of paragraph. But I am not reading it in its entirety. But only to demonstrate when or how 165 is
Which
exercised.
line, from which line you are placing?
Millard, I am placing, again, to shorten it further. Please take the 6th line of paragraph 12.
No doubt.
No doubt, under section 165 of the Evidence Act, a court has got power to put any question it pleases in any form at any time to any of the witnesses of the parties about any fact relevant, irrelevant, but that power is to be exercised in order to discover or obtain proof or proper proof of relevant facts. So, when witnesses are produced by the parties, trial is going on or examination, cross-examination is going on, the court definitely has a power under 165 to elicit some important aspect of the matter. It may be relevant, it may be irrelevant also. For the judge, it may be important.
Yes.
But just only, half sentence, please take, what our High Court has held in 1953. 1953, SCC Online, Calcutta, 181. Sunil Chandra Ray.
Para?
Please note down the paragraphs, but I'll place with only one sentence. Your paragraphs are 30, 36, 37 and 75, but I'll not place all these paragraphs. Please take its paragraph. The most important of these are paragraph 36. Can you have a look, Miller? Please take Miller printed page 18, 1/8. Please take the fifth line at printed page 8, which is part of para 36. I do not think. I do not think, yes, I do not think that there is any point in this criticism, because the criticism was that the judge has introduced new point. Criticism because if the prosecution omits.
Para 36.
36, I am not reading in its entirety. Please take me at the next page. Para 36 starts from printed page 17.
Yes.
Please come to.
I do not think.
I do not think that there is any point in this criticism, because if the prosecution omits to bring out a material fact, or the cross-examining counsel brings a witness to a state in which he cannot make his meaning clear, I do not think that defense acquires a vested right in such omission or confusion which the judge is not entitled to disturb. It is precisely for use on such occasions that the judge's powers under 165 are intended. The 165 is not intended for a whole hog trial where the judge will participate from the beginning to the end. Then, Milord, the last on this is Mukti Ghosh, 1974, SCC Online, Calcutta 139. Please take paragraph 4.
Yes.
The question then is whether any omission on the part of the prosecution to fully examine any witness of his due to his remissness or inadvertence can be made good and if so, how? The arms of law are long enough to provide for a contingency of the above nature. The provisions of law are those in section 549 of the code and section 165 of the Evidence Act, one being complementary of the other. These two sections between them confer jurisdiction on the judge to act in aid of justice.
Yes.
That's one 549.
Same, repeated, same.
Then para 6.
You have placed that.
Yes, the judge may act under section 165 of the Evidence Act in order to discover or obtain proper proof of relevant facts
Yes.
by any question he pleases in any form at any time of any witness, so and so.
All right. Any point you leave out, Mr. Dotto, you will get a chance to reply and come back to us. Let us get the
Very well,
feel
Milord, your
of that.
Lordship may kindly collate the points, Milord, which I intend to
Yes.
3 or 4 points, Milord, I have already argued. Whatever I have argued, Milord, I will not put those. But the next point, Milord, is, Milord, on the aptitude test part, Milord, where, Milord, the learned judge, Milord, has held that no aptitude test was held. Though, Milord, there are evidence galore, Milord, before the court on that aspect. Please note down the pages which I intend to, Milord, rely on this. First is the learned judge, Milord, has come to the conclusion that there was no engagement letters of the interviewers. According to the learned judge, Milord, they were called over telephone. This is what has been held at page 617.
Yes.
But, page 617, Milord, after that table,
and 617. 617. Yes.
where the first 3 lines is no questions was put to the interviewers. Then after that, the 4th line, it is to be noted that there was no formal engagement letters for acting as an interviewer. All the interviewers were called over phone to take such interview. And no pleading to that effect, no evidence to that effect. Then please take B.
Yes.
B is there was no guideline for awarding marks for aptitude test.
You have placed this.
Yes. Well, point wise only indicated. I know I placed the entire order. A, B, and C. But I have all the interview letters, the engagement letters of the interviewers with me. But now nothing was, Milord, before the court because these points did not arise. There is no pleading in the writ petition.
So you did not argue also.
Milord, there is no scope of any argument where, Milord, number 1 is there has to be a pleading.
That all right, but
number 2 is there has to be an argument by my friends on the other side also. If something is not argued, I will not jump and will not contradict that.
No. These 3 points has been taken. This is in this regard, court passed an order on 6th of February 2023.
Yes.
That order you did not challenge. That way the court proceeded. That these observations were there in the order of 6th of February 23. You did not challenge that.
I did not challenge it is one thing, that there has to be some argument, Milord.
That argument is there. This is the judge proceeds on this basis.
What may divorce any argument? There has to be some oral argument. I mean, I've got much to say on how the proceeding was conducted. I would not like to go through to that extent. But here your lordships will not find what arguments were advanced by the petitioners.
Where you shut down from making argument?
Could I say this, Milord? It is not possible. Please consider one thing, Milord. I take the writ petition, first sentence, this is my answer. I take the second sentence, this is my answer. I take the third sentence, that is not how we argue cases before the court.
No, the judge proceeded that I made these observations in your presence. And if that was derogatory to you, why didn't you challenge the same? That is why the judge has proceeded.
Milord, please consider, Milord, is it the jurisprudence of our justice delivery system?
Why you do not prefer appeal challenging observations of the court?
Please permit me to say this, Milord. I, as a counsel, everybody as a counsel, Milord, makes arguments on the basis of either the pleadings or what has been argued before the court. Milord, in a writ petition or in a suit or wherever, there can be 20 points, Milord, in the petition. And Milord, the counsel may choose to, Milord, argue only one point. Now the opponent, will the opponent reply to all the 20 points or one point?
All right. Yes.
Therefore, Milord, whatever your lordships find over here, I did not want to go to that extent now that Milord, some discussions are here. Well, my respectful submission is that the findings were not preceded by any arguments of the petitioners. Where I take responsibility, please note it down.
Yes. Yes, Mr. Lord. Finished. What?
Not to say, Milord.
No, you have no. What I was saying, it is not that we will shut you down.
Yes.
So let us hear your adversaries. Let us get an idea. If you want to contradict, you are there in reply. It is not that we are closing down.
No. But at the same time, kindly also consider this. If I don't convey my points to the court, I don't convey my points to my adversary also.
You have already conveyed.
There are other points also. This findings on the aptitude test and interview.
Very good. Then you tell us which are those points, but yes, we can take down that they can argue on that.
Paragraph 9 and 10 of the judgment below, the learned judge holds that aptitude test was not taken.
Noted. Yes.
No pleading on aptitude test. No pleading on aptitude test.
No, the learned judge said that no aptitude test was taken.
Yes.
Then why was this? Why this came that no engagement letter was also sent?
But I have to go back to 1875.
But your case is aptitude test was taken.
And whatever may be the evidentiary value of that so-called spiral, the aptitude test records were there. The learned judge did not look into it. I cannot.
Is that with us also?
Yes.
Part of the paper.
Part of the paperbook, Milord.
Yes, sure. Give us that page.
Your lordships may take from page 123. So 123. Please, for example, take page 153. But these were produced by the petitioners.
Huh?
These were part of the spiral filter. Part of the spiral filter. But this is that so-called spiral by Miller, which was prepared by the petitioners. Now, what are the records so far as the aptitude test is concerned? Please take page 153 onwards. But this is for district of Murshidabad, DPSC Murshidabad. Please take the column headings. Please take the 8th heading column. 8th column from the left, 3rd last from the right. Aptitude test marks is provided.
The aptitude and interview was held on the same date,
Same day.
same venue,
Same day.
and same interviewers.
Same committee.
Same interview.
Three member interview board.
And it was spread over various dates.
Various dates because this is district wise. This was done.
No, in every district only one date was fixed.
Different dates.
Different dates were there.
But these are produced by the writ petitioners.
Very good. Very good. Which other point you want to show from the judgment?
Please have a look to the rules.
No, you first finish off with the judgment. Which other point you want to say? Then it's up.
On this point, aptitude test is in the rules itself. Just have a look.
That is 2C, not 2D was there.
Yes. Which is at page 111.
That an agency may be brought in.
No. That is the learned judges finding. There is a
Agency
please take page 111.
That's just. No. Where is the date?
The aptitude test is defined at page 112 under rule 2C. Aptitude test means a test to assess the natural ability, teaching ability of a candidate.
Just. Is it that one? Page 100. What is this? This page 101, chapter 2, rule 3, rule 4, information of vacancies.
But that is the draft. No, this is the draft rules. It starts at page 100.
Page 100. These are the draft rules, yes.
These are the draft rules, but it was finally published, which is the next document.
That is 2016, page 111.
Yes. It starts at 111.
No. What is this then?
This is the draft rules which was published in 2050 or prepared in 2050.
No, that's okay. Aptitude is behind.
But after publication of the final rules,
No, 112 টা তো হচ্ছে এটা তো draft rule হলো এটা তো So you mean to say there were changes after the draft?
No. The draft rules, my lord, they have annexed in the repetition, therefore it's part of the paperwork also.
That then in the draft rule, rule 3
Yes.
does not tally with rule 3 of your fresh rules? Rule 3 is, rule 4 is information regarding vacancies.
Yes.
Uh,
No, rule 3,
Rule 4.
but in both rule 3 is role strength of a teacher.
5C.
No, but it has the aptitude tests. So, aptitude test.
না না আমি বলছি ওই এজেন্সি নিয়োগ করতে পারে বলছে না সেটা you can for the kindly come to your rules page 113
Yes, my lord.
information of vacancy subclause 5
Yes.
with the approval of the state government the board shall have the following power to lay down the modalities procedures or guidelines as may be engage clause C engage any specialized agency for the purpose.
Yes.
So you did engage one company.
But we had engaged a company only for collating the marks, nothing more.
Under which provision?
Look,
And not under this provision.
yes, may I clarify this thing? There is a feeling that the agency was appointed for the purpose of selection, interview, aptitude test, etc. The answer is no. The agency that was engaged is only to add up the marks of the candidates, nothing more, nothing.
Under which, where from do you get that authority that I will engage an outside agency for tabulation of marks?
No, it's not a tabulation of marks as
Or
such.
adding up?
Yes, it's not.
So you must be having some.
Facilitate me. That had nothing to do with the what should I say? The quality of the interview, the selection.
So can we take this from you that for there was an engagement of an agency for whatever reason may be,
I'll give that.
but that agency engagement was not provided under the rules. You did not have any authority to do so. আমি তো ভেবেছিলাম এটা বসে রয়েছে না ধোবি বললো দেখলাম ওইটা আগের পেজটা কত বললো জানো ওই যে ওই না 153 বললো না মানে তোমাকে আমি ইয়েটা দেখাচ্ছি আপনি এনগেজ করেছি হ্যাঁ 120 ঠিক আছে then what is page 123?
123.
প্রাইমারি টেট 2014 লিখিত পরীক্ষা 150 ওএমআর শিট তৈরি এবং তার মূল্যায়ন করার বরাত পায় শ্রী এস বসু রায়
এগুলো এদের তৈরি, এগুলো আমাদের কোনো ডকুমেন্টস ছিল না।
and company.
That is there for the petitioner to explain. This is not. This is part of
Then
the.
which agency did you engage, Mr. Dotto?
I'll check up this point.
Please take up, and subject to what you say, whatever we went into this as regards agency, this word agency only features under rule 3 sub rule 5 sub clause C. C or D. Apart from that, there is no provision for it. So you will you have admit that we took the help of a particular entity for the purpose of very good. Yes. Any other thing you want to show us, Mr. Dotto? Finished.
Please have a look at 2 or 3 portions of the rule.
That we will go into, Mr. Dotto. If anything in course of submission, we will hear you. Please conclude your first thrust.
Please take me at rule 8, sub rule 2.
Yes, what you are saying, rule?
So Rule 2C defines what is an aptitude test.
That is page
Page 112 of the Gazette notification.
yes. What is your submission?
You know, the aptitude test means a test to assess natural teaching ability of a candidate.
Yes.
Now, Millard, then kindly take Millard rule. Then please take Millard rule 8, sub-rule 2. At page 115.
Rule 8, sub-rule 2. Yes. For what?
But on the aptitude test part.
Shall call selection committee will.
Committee shall call all qualified candidates as mentioned in sub-rule 1 for vivacy or interview and aptitude test. The performance of the candidates who will be called for vivacy or interview and aptitude test will be assessed separately by the interview board for formed for the specific purpose. Then academic qualification, etc. marks will be added so and so.
Yes.
Now, my lord, the learned judge, my lord, returns the findings at paragraph 9 and 10 of the judgment. So first judge says there was no aptitude test. Then his lordship says that marks were not given to the candidates against the aptitude test was wholly illegal. So it is self-contradictory. That is your argument also. And paragraph 10, the learned judge holds that it is a false exercise to hoodwink. Please take page 618.
No, what you have shown us the definition, na? That rule 8.2.
8.2.
So tell us this
definition at 2C. 8.2 is the procedure.
Page that is.
The page was
Page 112.
112.
Yes, 112.
ইন্টারভিউটা করছে না এটা বুঝতে পারছি না যে দেখছেন কমিটি রুল 8 now rule 8 you are citing page 115.
Yes, 115.
Selection committee shall make prima facie scrutiny of the duly filled in application form submitted by the candidate having qualification as mentioned in rule 6.
Yes. And 2.
Now, what is the definition of a selection committee under this?
So the selection committee is defined.
Is it defined?
Yes. Selection committee.
Selection committee is not defined. Is it defined?
Rule 7. Rule 7.
Rule 7.
Rule 7.
Rule 7. Later on, it got amended.
Yes, selection chairman in council. So, what is the function of the selection committee? Committee will call all qualified candidates for vivacy or interview and aptitude.
Yes.
Now, the performance will be assessed separately by interview board formed for the specific purpose.
Yes. All interview boards were constituted.
Now, the selection committee's function is to call the candidates and to ask them now, first stage is academics, how much you have got. Now, next stage is interview, third stage is aptitude. So, for that aptitude and interview, you have constituted an interview board. That is your argument. Now, what is the method of selection of these persons in the interview board? Any reflection under the rules is there that you can select this person?
That is below para 7.
So, is that the discretion of the selection committee?
Yes.
Then where do we find that the selection committee will appoint the interview board? What you are saying?
Regarding selection committee, because according to the rule 7, my lord, the board ought to constitute a selection committee council-wise.
Amended rule.
I'll kindly read text rule 7. May I please? The board shall constitute selection committee within the jurisdiction of the council. This is the definition of council. That means DPSC-wise. But here the case is that
definition of council is DPSC.
Yes, DPSC.
Every district.
But here in the 2016 selection process, board not constitute this selection committee council-wise. If they constitute the council-wise, producer. Yes.
Separate argument. We are wanting to know what is the procedure under the rules towards engagement or towards constitution of the interview board.
Interview that is mentioned in the rule 7 itself. First, there is
rule 7. Where is it?
Rule 7. Thereafter, rule 8. May I read it? May I read it?
Read it.
Kindly see. Rule 7 is that the board shall constitute selection committee within the jurisdiction of the council with the following members. That is chairman of the council. District-wise, there is a DPSC chairman, secretary of the council, special officer, and that the validity of this council selection committee is 2 years. Kindly take the rule 8. The selection committee shall make prima facie scrutiny of the duly filled application form submitted by the candidates having qualification as mentioned in rule 6. The selection committee shall call all qualified candidates as mentioned in sub-rule 1 for the viva voce or interview and aptitude test. The performance, that is the only thing. So selection committee is the person they will call. There is no such interviewer board.
No, they will call the candidates.
Yes.
But this interview board will interview the candidates and take aptitude test.
That is not the provision.
Read the line.
Yes,
selection committee shall call all qualified candidates as mentioned is for viva voce or interview and aptitude. Now, performance of the candidate will be called for, who will be called for viva voce or interview shall be assessed separately by the interview board formed for the specific purpose.
Yes.
So, where is the provision under the rule that this is the method in which the interview board will be constituted?
Interview provision is not there. Yes. Clear. Still. Yes, that's.
Which is not there.
My paper. The amendment is not in the paper book which the documents are having.
Oh,
The amendment is another compilation.
Appeal number.
Amendment, what is the date of amendment?
In the year 2016 itself.
23rd September 2016.
Date of amendment of the 2016 recruitment rules. 23rd
September 2016.
Very good. Show us that. We are keeping it permanently. We are keeping it permanently. Yes, tell us what is that.
Sir, if you are not sure, I can't take the second page.
Rule 7.
Yes.
In sub rule 1, substitute the following. The board shall consider
Selection committee for the purpose of selection of eligible candidates and preparation of panel of such candidate or appointment of teachers in primary school within the jurisdiction of the board. Then Millard, please take Millard C. A I have placed. C says after rule 3, insert the following. The board may, if necessary, constitute one or more subcommittees for scrutiny of testimonials, stroke, for conducting interview, stroke, aptitude test and other purposes as may be required, the decision of the subcommittee so and so shall be bound by the decision of the board. Now, these subcommittees, my lord, which were constituted, had conducted these interviews and aptitude test.
So after sub rule you are inserting.
Yes.
You are not throwing away the interview board as referred to under 3(2). Under rule 7, under rule 8,
yes.
interview board is still there.
Yes.
You are adding a power that I can now appoint subcommittees.
Yes.
Then it becomes more contradictory.
Selection.
Rule 8(4) দেখো রুল 8(4) বাদ দাও, ওর অ্যামেন্ডমেন্ট করেছে রুল 7 সাব রুল 1। রুল 7 সাব রুল 1 বলছে সিলেকশন বোর্ড উইল কনস্টিটিউট সিলেকশন কমিটি। সিলেকশন কমিটি সাথে অ্যামেন্ড করে ঢুকিয়ে দিল এই যে সাব রুল 3 তে
কোন সিলেকশন এই তো নেই
ইনসার্ট
এই সাব
7 any member of the committee other than the may resign such and such, এটাতে একটা সাব করে দিল board will constitute. Now Mr. Dotto, give us the clear picture. Selection committee definition rule such and such, members will be such and such. Interview board rule referred to in rule such and such will be constituted by 3 members by any guideline or procedure wherefrom you are getting that power to constitute.
Please keep my lord 112 open, 114 open of the paper of my paper book. Please have a look to rule 7.
Yes.
The board shall constitute the selection committee within the jurisdiction of the council. Instead of council, please read board, because this is the amendment made, my lord, which I have handed up. So it should read like this: the board shall constitute selection committee within the jurisdiction of the board with the following members: chairman, secretary, so and so, so and so, so and so. Then comes below sub rule 2. The selection committee shall normally function for a period of 2 years. So this is the life of the selection committee from the date of its first meeting. Then it says, provided that the board may during the said period reconstitute the committee. No difficulty on that. Then comes below sub rule 3. Any member of the committee other than the ex officio member may resign within 1 month notice to the chairman. Instead of chairman, it should be read as the president.
No, we are not getting that answer. Na?
Yes.
How the interview board you have constituted.
Yes.
Please take instruction on that.
Yes, I'll take instruction. Very well. I'll take instruction.
On that.
Well, I'll take
no, you concluded, Mr. Dotto. We are taking down the points. You have said.
So, my aptitude test taken.
No, panel was published.
Yes, yes.
Panel was published.
District wise published. ভাই তোমরা তো তোমাদের টাইমটা পাবেই।
All right. No, we forget about them. We are asking you whether board published a panel.
Yes. But I'll tell you, Lordship Miller.
So
the fact that the panels were published at the various what they call council, this of the district primary school councils is evident. Number 1. Number 2, Miller, challenging those panels, hundreds of writ petitions were filed. I don't know how can my learned friends just say not published, not published. Then how could Miller people challenge those panels? If they want to keep their eyes closed, that doesn't mean Miller panels are not published. So Miller, this is Miller on the aptitude test. Next, Miller, the learned judge comes to a conclusion that more marks were given in interview and aptitude test to persons who had got less marks.
That you have argued.
Yes.
We are taking down. Yes.
Then, my lord, yes. Then, my lord, we have a point.
Yes.
That, my lord, delay in filing of the writ petition was not considered, my lord, by the learned judge. একবারে দেখে একবার জেনে না হট করে আমাকে বুঝতে দে ভালো করে দুটো মাথায় রাখ না, একটা এজেন্সি অ্যাপয়েন্টমেন্ট আর একটা হচ্ছে সিলেকশন কমিটি কনস্টিটিউশন, এই দুটোর উপর তো ইনস্ট্রাকশন চাইছে একটু।
সেই অর্ডারগুলো Now, Mr. Dotto, please do one thing for us. In some of those 80 applications, we took the trouble. In some of the applications, it was said that earlier writ petitions were preferred, challenging non-inclusion of names in the panels published. Now, in non-inclusion, those writ petitions were not interfered with in several matters.
Right.
So you have to give us the orders in which similar prayer was rejected. Please.
But this is one of my points where I'll give those figures.
Rather, I think I shall.
Already লিখে রাখ Constitutional Selection Committee সেকেন্ড হচ্ছে
এটা ওই যে কালকে তোমাকে নোটটা পাঠালাম
and how agency was appointed under which power. হচ্ছে কোন রিট পিটিশনে প্যানেল ওয়াজ নট ইন্টারফেয়ার।
দেখো একটা জায়গায় আছে
অরিজিৎ ব্যানার্জি।
Yeah, please take down. Yes, Mr.
Yeah, লেখ বলছি।
In Can 10 of 2023.
লেখ Can 10 of 23.
Which was filed in connection with MAT 873.
MAT লিখে রাখ, ভুলিয়ে।
So in that application, they have prayed for direction to publish the panel of selected candidates. But your contention is panel was published. What is your answer? You please.
Yes. Well, there are at least 2 orders, my lord, of honorable single judges of this court. But at least 2 we have.
That is Can 12 of 2023. That is also filed in connection with 873 by one Shopon Kumar Badwi. He said
873 met.
In paragraph 13 of that, he said that he had preferred an earlier writ petition. And the same was adjourned by an order. And that is still pending. You have to give us the status of that. Similar contention was made in Can 13 of 2023.
Can 13 of 2023.
And one of the writ petitions mentioned was Prabhat Manna. These are few we are checking it out. Please you take a note because that is why we want to hear the adversary. Then the thing comes out. Then we can explain your cases.
But kindly note down, Millard, my points, Millard. I have something to offer also. These are all in defense.
Yes, what more points? Please tell us.
First is, so far as we are concerned, there is a delay in filing of the writ petition. 1 point,
we have taken that. We have taken note of that.
Yes, but in support of this, Millard, please note 2 or 3 judgments. One is 2024.
Yes.
SCC online. SC 1189. But this is in respect of 2020 selection process. Your lordships are considering 2016 selection process.
Yes.
2020 selection process, Millard, when the matter ultimately goes to the Supreme Court, Supreme Court directs that there would be no appointment after expiry of the panel. There would be no upon expiry of the panel, because in the writ petition, the prayer was to allow them, to appoint them in the 2016 selection process.
Para 29.
Well, there are various paragraphs, but please take para 29. Please only read Miller para 29. There are a lot of paragraphs, but only para 29.
All right.
In the light of the above discussion, the following conclusions are reached. The manner of shortlisting candidates for appointment suggested by the division bench in the impugned judgment is inconsistent with the procedure laid down in Rule 8 of so and so and cannot be sustained. The panel or merit list as notified in so and so stood extinguished after the expiry of 1 year, that is on 15/2/22 as per Rule 12. No extension by any competent authority was granted. 4. No further appointment is permissible from the recruitment process initiated on 2020. In our case also, Miller, panel was published in January 2017. It expired in February 2018, and the writ petition was filed in 2022. Now what happens is, where there's Shumit Ghosh today. সুমিত ঘোষ বসে মৌটুসি রায়, এটা 2016 তো সত্য।
On the same point.
No,
delay.
only to just give me a moment. Now, Millard, in relation to this selection process, Millard, a matter goes up before the Supreme Court.
Yes.
Where in 2016 selection process, when it goes before the Supreme Court, where the Supreme Court says that in relation to 2016 selection process also, the Ali Hussain Mandal judgment, the previous one which I've handed up, will be taken into consideration by the learned single judge. Please take the last paragraph.
This was subsequent to his lordship's order.
Yes, but this is 1912, yes, subsequent.
So your argument, Ali Hussain says, a panel expired, go home. So that is to be followed here.
Yes, Ali Hussain is in 2020. This should also be followed in 2016 also. Then, Miller, on the basic principle, please note down two judgments.
এটা নতুন ব্যাক করো, এগুলো সব ঢোকাও। Yes.
Just note down the citation. I'll hand up, Miller, the
yes, tell us.
case laws. 2014, volume 4, Supreme Court cases 108, paras 13 to 17, and 1986, volume 4, Supreme Court cases.
No, this is on which?
Delay.
Oh, delay is also delay.
Yes.
Another is 20.
The last one is 1986, volume 4, Supreme Court cases 566, para 24.
কার্তিক এইগুলো না ওই এই যে যে ফাইলগুলো আমার কাছে এসছে ওইগুলো অ্যালং উইথ আজকের যে জাজমেন্টটা হয়েছে ওই যে দেখো একটা জাজমেন্ট ছিল এই যে না না ওটা কোথায় গেল
This is the first point from my side. The second point from my side is the writ petition was not amended.
Amendment for what? For
All point, most of the points are not in the writ petition.
there was no challenge against the
Nothing,
panel,
nothing.
etc., etc.
No challenge to even Miller these appointments which have been set at naught.
And no person was no in the Priyanka Naskar case, no successful candidate or person similarly situated.
Not a single one.
No private respondent was there.
No private. 140 writ petitioners, no private respondent.
1 for 39.
That's it.
Yes.
Millard, on the Millard.
On lack of amendment also you want to cite a judge.
One or two. One judgment made. I'll not trouble your lordship with or rather multiply judgments. AIR 1981 Supreme Court.
Page
588 para 6. Yes. AIR 1981. এত জাজমেন্ট বের করেছি আমি খুঁজে পাচ্ছি না এসএস শর্মা দেখ 81 SCC 397.
This is one group.
Yes.
Starting from you, this is same group.
Yes. We are same group.
He's an outsider.
Yes, he's an outsider.
Then why you are sitting there?
Yes.
Mr. Vadayat?
I am appearing in respect of the candidates from the dinner.
We are happy to learn that. We are happy to learn.
Then you must be this side.
Yes,
That's
you should
yes,
be this
yes.
side. You should be this side. My brother says something else. No, you said AIR 1981.
I don't have the AIR copy.
This is same judgment.
Yes, madam.
Paragraph is also 6.
Yes, madam.
কার্তিক এগুলো একটু আমাকে দিয়ে দেবে আজকের গুলো একটা বান্ডিল করে দেবে আর আগের দিনের বান্ডিলটা আমার কাছে লেখা ছোট একটু পড়ে দেবো কারণ ওইগুলো নোট করা আছে এইগুলো নোট করা নেই
হ্যাঁ
Yes.
Now, Millard, my main point is predisposition of the judge. But please give me 15 minutes on the next day. I'll not take much time.
No, you finish it. We are here. We will.
Well,
that you have said that you have said with responsibility that these were never argued. The court proceeded.
That is one thing. But why I say the predisposition of the judge, Millard, I have got 7 or 8 facets in support of that. Please just note down the facets. Number 1 is where the tearing hurry of the learned judge in hearing the matter.
Yes.
Where the matter was heard, but on the first facet, on 15 occasions between 2nd of December 22 and 11th of May 2023.
It was heard on 15 occasions.
15, 1-5.
In between?
2nd of December 22
Yes.
and 11th of May 2023.
Yes.
Number 2 is on 17th of January 2023.
Order passed.
No, on 17th of December, we were not allowed to make any submission on
17th
January. I'm sorry, 17th January 23. We were not, or the board was not given any opportunity to make any submissions on the aptitude test.
Where is the 17th January order page?
Well, this is at page 421. And without allowing us to do so, Millard 165 was exercised.
Yes.
Third aspect is, Millard, on 24th of January, the board was 24th of January 2023, the board was disallowed to come up with any affidavit in opposition. This is at page 425, or the relevant portion where I am placing Millard at page 425.
No, 425.
Yes, please take me at page 425, which is the third page of the order of 24th January.
Is it said refused?
Yes.
425.
Please take the second paragraph.
New at this evidence of
I will not allow filing of any affidavit in opposition in this matter by the board.
Yes.
Then, Millard, please take, Millard, what is very surprising is, please take, Millard, page number 421 once more, 17th of January order.
Yes, that you have said, board not allowed to submit on the aptitude test.
More important is, Millard, the next paragraph. Kindly see, Millard, how could the court ascertain who were present in court? But I've got serious apprehension, Millard, on this aspect. There are so many persons present over here. Well, does the court know, Millard, who are present over here? Please have a look to this order.
Why not? I know you, I know.
No, yes, definitely.
All the councils are.
But the court doesn't know that person. Partha Bhattacharya. Partha Bhattacharya.
So you should take a joint effort against him. This way it will not. Serious.
How can it be a joint effort? It has to be.
421.
Yes. Please take the second paragraph at page 421. As a large number of petitioners were present in court, I decided to exercise my power under section 165, and I asked some questions after administering up to 7 of such candidates being petitioner number so and so. How could the court know that these petitioners are present in court? Who has given the list? Who has identified them?
No, Mr. Tiwari was representing.
No. But the judge should have recorded that on the either on the request of Mr. Tiwari. No.
Mr. Torunjyoti Tiwari was there.
Yes, court.
But let him make a statement that he had introduced these 147, 915 and so and so. Let him make a statement. I'll deal with it. We'll deal with it.
No, I am representing 10 persons.
Yes.
So court may say that Mr. Chakraborty, I will question petitioner number 4, 5 and 8.
Yes.
What will I do?
First is
that
not.
is not
These persons were from different districts. Court asked specific questions, but their districts were not identified. Thereafter, they were chosen.
Nothing reflected in the order sheet.
But everything.
Miller, there is.
This is your
Miller,
what you are alleging.
Miller, with all Miller humility.
Mr. Tiwari, we shall hear.
Yes. Where the witnesses were not identified, neither did the petitioner's lawyers say whether he was present or not. I don't go into that. That X, Y, and Z are present. Examine them.
Yes, page 421.
Then kindly take Miller page number 423.
Tell us now what has been said there.
Where the order.
Same order. Same 24th January order.
No, yes, 24th January order. Where the order starts like this. I directed the petitioners that at least 2 candidates from each district are to be present before the court. As the court wants to know from them so and so. Where is this direction? Then there was no such direction. Please have a look to me at page 420.
Mr. Tiwari, you take note of this and you give your answers to this. All right. Yes.
Then, my lord, kindly take out of the blue moon, my lord, 1 person is called.
Yes.
Please take page 436.
Yes.
Well, my respectful submission is why suddenly someone is called from the jail.
In view of the alarming situation pending, judge was taken cognizance of that.
We need to have it on record, with respect, Miller.
That has been referred to in the order.
Miller, please take note whether the previous order records that. Please have a look to the previous order. Kindly see at page 432.
So that was a suo motu direction.
Yes. Now, any suo motu direction must be preceded by some activity in court, by some submission in court, by some documents placed before the court. Something, has to be, on record to justify, calling of a person. Then, I'm sorry. I'm sorry. 436, which is on 5th of April 2023, my lord. Your lordships have found, my lord, one particular person has been called from the superintendent, from the correctional home. See what is done on the same day in the next page, page 437. 5th of April 2023 at 4:20 p.m. What happens? See kindly have a look to the first line. Learned advocate for the petitioners has concluded his arguments. Same day.
Page 436.
437. 436 means the gentleman was called.
Hmm.
And on the same day at 4:20, the learned judge records that the learned advocate for the petitioner has concluded his submissions.
Yes.
Now kindly take me, lord.
Now the court puts the questions.
Put the question. On the same day, kindly take the last paragraph of that order at page 440, that is fourth page of that order.
Yes.
Last paragraph.
Supplementary evidence disclosing the documents as there. That you are doing.
Yes,
Supplementary
yes.
evidence.
After conclusion, on the same day, first paragraph noted that the petitioners have concluded their submission. Last paragraph, supplementary affidavit of documents taken on record. Now, when was this? On 5th of April.
So what does it? What is the wrong, Mr. Groth?
There apparently there appears to be nothing wrong. Now, kindly take 19th April order.
Page.
Which is at page 444. Kindly see the first paragraph. After conclusion of hearing of the writ petitioners, if at all on 5th of April.
For completion of the pleading side.
I adjourn the matter and request the board to file their affidavit in opposition. After completion of hearing of the petitioners on 5th of April. Now I have been given the opportunity to file affidavit in opposition when previously it was rejected.
This was accepted by you, Mr. Dotto.
Milord, it is not possible to run to the division bench with every order in appeal.
That line could have been recorded, which what you are arguing today, your counsel was present.
Well, I was present. I was personally present. I was present.
Then you have to go back to the judge and ask that what to.
Yes, I want to cross-examine that judge. 1875, I will place before your lordship.
What 1875?
Where, my lord, the judge incorporates his personal knowledge of any matter, how could that person be called? He cannot put into the judgment anything unless he appears as a witness. This is 1875 judgment. It's not like, my lord, dispensing justice over here doesn't mean that call anybody, anytime, anywhere, adopt any procedure you like. Without arguments of the petitioners, the judge records that the petitioners have concluded their submission. Next breath, call X. Next breath, call Y. Next breath, okay, you submit that document. Then, okay, if board you have not filed your affidavit, file your affidavit. But the proceedings has to be conducted in a manner which inspires confidence in the parties. But the order can be against me. The order can be against me. Why not? No, all that, my lord, we as counsels or the litigants that they expect is that in a proper proceeding where the court will hear the parties and pass orders.
Yes. All right, now we will say you have concluded. You will again come and say that I have not concluded.
Therefore, I am saying I have not concluded.
We will face that comment again.
No. Milord, this is where, Milord.
When I say the Advocate General has concluded his argument, do I stop you from giving reply?
No.
I will hear you in reply.
Definitely, Milord. But there, yes, Milord, your lordships would hear me, provided on the next day I come and say that, Milord, I have recorded or I had submitted that the submissions are concluded, but I find I have left 2 judgments.
Yes.
Or I come and say that I have missed 2 points, or I have discovered something. So kindly permit me to reopen. Not that today your lordship will record that arguments completed, and the next day the court will allow my adversary to file their affidavit in opposition. Well, what is very surprising is, what I have shown so far, but in fact the petitioners ought to have been aggrieved that after you have concluded my submission, how are you allowing the board to submit their affidavit in opposition? I will not get a chance to deal with that.
Exactly.
Therefore, that is why I say it is surprising. Yeah.
Yes.
Then, Milord, finally, Milord, 11th of May, Milord, 2023, Milord, the hearing was concluded, judgment reserved, and on the very next day, well, there is no harm in delivering judgment on the very next day, but keeping the sequence in mind, where
12th. Judgment was on 12th, no?
12th, the very next day.
It was concluded on
11th. Milord, Justice Sanjeev Banerjee, Milord, had imposed a rule on his lordship that his lordship would deliver judgment within 48 hours. Hearing for 30 days, judgment within 48 hours. But I can understand, Milord,
what? His lordship did what?
His lordship used to follow that practice. That no matter how big the arguments are, I am going to deliver judgment within 48 hours. And the honorable judge scrupulously followed it. But I can, but this is such a case. Why I say this? Right? There's something more than what meets the eyes. Why I take, Milord, this risk?
You need not traverse on that.
But I cannot, Milord. Milord, when Milord, kindly permit me to say this, Milord.
We will hear him.
Yes.
Questions you have put, we will put questions to them.
Yes.
Then we will decide.
Your lordship would hear us first, or the other.
Yeah, that we will decide. প্রথমে লেখো Mr. Dotto, learned senior.
কি আছে আর কি বাকি আছে
আর কিছু বাকি
ওটা আদৌ করুক ওটা
কি বলছে কিছু বলছে
Milord, please record one thing, Milord, so that there is no misunderstanding. I have a few points left, but please permit me to raise those if I require, Milord, in reply. Otherwise,
Dotto, we are hearing you substantively. We do not shut out the councils. We never do that.
No, definitely.
If you have, and your friends will also not shut you off. That much of understanding we should have. No, it is just a judge delivers a judgment after hearing it. We also put up matters for clarification, because when it goes for our signature, doubts are, then we keep it. Now, after you finish, who is in aid of you? Then Mr. Mojumdar, will I ask them to just a moment. We were wanting to know if you may be having additional points on what Mr. Dotto has submitted. So can we do this, that at least if we hear their part of the story?
Kindly hear us first. All the points, whatever points are there. Get all the points. Can hear this.
But you people are how many councils we will hear?
Be as economical as possible. All council. But my lord, kindly hear us, kindly give us some timeline, we will come to. We will come, but hear us all. I have one.
No, we would request you, both all senior councils are there. Why don't you sit and make a homework, and any one of you.
That's likely there cannot be anyone, but of course there will be very less number, not everyone. Not be one. Be approximately.
So you are representing which persons? No, which you are representing which person?
I am representing experts who are appointed from 7.
No, ওই দেখো তো ওই অর্ডার শিটে ধরের নাম কিসে আছে?
Candidates what in service.
এই আমার বাইকটা নিয়ে নাও।
এই নিয়ে সেজন্য তো তোমাকে বলা তারপর আমরা এটা
Hear us all. Why you not kindly hear us all?
No, Mr. Mojumdar, then the matter will never end. We are asking your assistance.
My lord,
I have compared myself in one matter, in one point. We have discussed this. We will not.
I'm led by Mr. Joydeep Kaur. He will outgo on the point of section 165.
But that gets the point. It may not require to enter into the entire domain of the matter that Lordship is seeing. There is a possibility. I don't want to disclose anything on that. There is a possibility that Lordship might find it is not such a big matter. It might come to an end on one point. There is a possibility. I test the couple of points from us. After that,
We have tried ourselves, we have applied our minds kindly.
আমি কি বলবো যে আমরা ফার্স্ট ছিলাম আপিলে
You are representing the persons who have already been brought on record.
No.
Any one person says
we are the appellants.
you are appellants in the other appeals. In the other appeals, you people are the appellants. So how many people will argue before us? Some restriction has to be there. Everyone cannot take a one day every day.
As against 30,000, who are going to lose the job.
That cannot be. That is the magnitude of the dispute. So we cannot hear 36,000 advocates today. We will hear only restriction. No, Mr. Dhar, Mr. Mojumdar, you sit together and find at least. We will give you 1 day or 2 days. You finish it off.
But I led by Mr. Joydeep Kaur and Mr. Sujit Mitra. I need only a day.
We will allow these other appellants to argue. Mr. Dotto has taken, he has substantively argued. We would request you that the points which have been left out, you let us know.
But we will, Mr. Kaur will argue on the point of section 165.
For that, we will give you 2 days. We will fix the matter at 2 p.m. 2 days. We will finish off your argument and then we can.
And only one thing before that, because the appeal is not in proper form. Because of that, there are several addition of party which is implemented in pursuance of the court order.
We will sort it out.
Yes, and another thing is that, my lord, because the court asks 4 questions for taking instruction, and kindly ask another instruction on 29th November 2022 regarding publication of panel, the board published a notification where they stated on that day in the year 2022 that a erroneous loss which is annexed, my lord.
We will ask
Yes,
Mr. Dotto what we said
Whether
at the
panel is
first,
yes.
that to show us the order of, you will give us those orders.
Yes, because of that till date non-erroneous panel is not yet filed.
We will hear you.
Yes, yes. my lord.
So please
Yes.
jump upon them, let them
No,
conclude.
yes, yes. my lord. Yes, yes. Yes, because with this procedure, another parallel procedure was there. Somen Nandi and Ramesh Malik, and that was in court knowledge.
We will sit at you. We will continue till ওটা রেকর্ড করে নাও তো 40 minutes এর বেশি দেবে না we will record it in our order that you will not take more than 40 minutes.
Just like chess.
Mr. Dotto, learned senior advocate, appearing
So, my lord, I can make it and hand it over to your lordship's officer.
The 2 copies will be hand up to your lordship's office.
No, no, it's all right. If those documents are there in the paper book, there is no problem.
In my paper book, they are not there. In a compilation prepared by Mr. Shakroshen, that is there.
I have prepared a convenience brief. Shakroshen was also using it. I have the books annexed in that. Very
ওটা কিছু ছেড়ে কি বললাম সাবমিশন কনক্লুড করে দিই
to my lord. No. I've been given a task. I know that I am a creature of instruction. Who are in the court, they will say that they have not been heard. Therefore, Milord, I appeal to my lords.
You are for whom? You are for whom?
I am appearing in respect of the persons who had not been impleaded initially, but have been allowed by the division bench of my lord Justice Shomenchen. And thereafter, Milord, we have prepared independent appeal by Milord, a group of candidates who belong to the district of Uttar Dinajpur.
So we will hear you.
No, I am only saying because Milord, my stand is akin to these Milord submissions made by Mr. Dotto. Only thing, Milord, few points. I just say that I will be only taking 10 minutes time.
So that is what we have recorded. That we have requested. As we were told, Mr. Bandyopadhyay, when it was first heard, he said that I will come back and make my argument. On the first day he was there. That is why if 23rd we are keeping, he will be here.
Yes.
We will hear him first. Once he finishes up, then we will distribute the time amongst you. And hope 24th আছে বললে না? And we hope and trust that on 23rd is we are fixing at 2 p.m. We can keep it as a continuing pattern on the next date also, so that they can finish.
That's only my appeal. Because Milord, otherwise I will be in a difficulty.
পেপার বুকটা ভারী বেশি
I am standing in
বুঝতে পারলেন
So please inform Mr. Bandyopadhyay that on that date at 2 p.m. ask him to come and complete.
My lord.
I am always in the wrong side. Therefore, Milord, I am in the wrong side. Therefore, this thing has happened.
এটা আবার
All right.